Yep, it's
All
there.
right.
You're recording.
Okay. And all right. So can you see the PowerPoint?
I see the rocks again you showed me a minute ago, or it looks like rocks or crystals with the little black picture with words in it.
All right. Okay, so I'm going to start this again. And if it screws up, would you just interrupt me and tell me if it messes up and you can't see it or anything?
Sure,
Justin, I
no
appreciate
problem.
it. Okay. So this presentation is called The Power of the Word, and it's all about affidavits because the affidavits are the cornerstone of the private administrative process. So we're going to start with, how do I get it? There we go. Maxims of law that apply to affidavits. All are equal under the law, so no natural person has more rights than another natural person, and no corporation has more rights than a natural person. So I hope that makes sense. No, the law states that all persons are equal. The maxim of law is that all are equal under the law. So each it that's a rabbit hole I could go down, but I'm not going to. Okay, so the next one is in commerce, the truth is sovereign. So that's the reason that we put the jurat and the penalty of perjury statement on an affidavit. And without that, it is not an affidavit. It's just a statement. You want to make it an affidavit when you're doing the private administrative process because what you're doing is you're preparing to file suit in a court of law. So when you begin the administrative process, you want to document everything and prepare a file that will be easy for you to take to a courthouse and get a judgment on because you have all the evidence. And so that's what we're putting this thing together so that your private administrative process is the foundation of a suit that winds up having everything that you need. So the truth is expressed in the form of an affidavit. An affidavit establishes the truth in law. A matter must be expressed to be resolved, and if a dispute is addressed by an affidavit, it must be resolved. An unrebutted affidavit stands as truth in law. The affidavit becomes the truth if the matter is not resolved. Now, these are important things to remember because in the next slide, let me see if I can get this to be bigger. Okay. An unrebutted affidavit becomes a judgment in commerce. You can enforce an affidavit as a judgment in court. If it's not rebutted, it is absolutely the truth because it is under penalty of perjury. It is what it says it is. So that gets you a lot further than you don't have to fight about the facts that are laid out in the affidavit because if it wasn't rebutted, it is the truth. Who leaves the field of battle first or does not respond to an affidavit loses by default. And if you or the opposing party ceases to respond, the matter is resolved. Sacrifice is a measure of credibility, and this is why we put the penalty of perjury statement on an affidavit because it gives the document the credibility and the weight that it needs to carry to be the foundation for a lawsuit. A lien or claim under commercial law can only be satisfied by one of the following actions: a rebuttal affidavit of truth supported by evidence, point by point, payment agreement, or resolution by a jury according to the rules of common law. So when you send an affidavit and you specify these are the terms that I want you to respond under, these are the terms that you are required to respond under. They have to respond under those terms or it's an insufficient response and that can work in your favor. So the outline for the affidavit is you want to title the affidavit, identify and state who the affiant is, what capacity you are in, and how you're approaching the exchange. Summarize the subject matter, give a notice of all statements of fact, certify that all your statements are subject to a penalty of perjury, so you do that at the very end. Identify who the notary is within a jurat. And honestly, a lot of notaries don't even know what a jurat is. They use it every day, but they don't know that that's what it is. So that's actually a term that is more common to us because we're studying what it is. But several notaries that I have mentioned that to did not know what a jurat was until I showed them. So sign and have the document notarized, assign the document a reference number, page numbers, and exhibits. So you want to combine, you want to connect the document pages by numbering the pages. Say this affidavit has 8 pages, and then you number the pages, and it has 5 exhibits. So this affidavit has 8 pages of affidavit and 5 exhibits that go with it. That, and the exhibits are separate from the page numbers unless you're including them. Make sure that when you put the proof of mailing in there, put the actual number of pages that you put in the envelope. And that just solidifies your mailing, and it makes it organized, and it's easy to see what was actually in there. It's proof of the mailing. Your proof of mailing, I'm kind of confusing the issue, but you want to say something like, I certify that I certify under penalty of perjury that I put an affidavit that was 3 pages, 5 exhibits, and a allonge, and it totaled this number of pages. And that's what you put in the proof of mailing. You send it certified, return receipt requested, and you put the exhibits in. You don't put the original exhibits, you put copies of the exhibits in with your affidavit. You save the originals because, remember, we're building a case for court. So you only send copies when you're doing the private administrative process. Because what you're doing is you're preparing for the eventuality that you may have to go to court. Hopefully you won't, but you're going to be prepared if you do. Questions to answer when you're issuing an affidavit. Who are you and what capacity are you standing in? Who are they and what capacity are they standing in? What jurisdiction do you have? What jurisdiction do they have? So, for instance, if you're a natural person, then you're a federally protected consumer, and they are a corporation, or they are a debt collector, or they are a financial institution, and whatever capacity and what rules apply to them, you need to lay that out in your affidavit and let them know that they're beholden to these rules. What jurisdiction do you have and what jurisdiction do they have? Well, that's going to depend on your case and who you're dealing with as well. But in a commercial capacity, they have statutes and codes that they have to adhere to. And when you're dealing with them in a commercial capacity, you have to adhere to those laws too. But if you understand who you are, there are some cases where you don't have to adhere to commercial rules and laws. And you need to know what those are. So that's why it's important to just keep studying. What is your claim and what law supports your claim? And so when you're answering at this point, when you're going through this slide here, this is where you're writing an outline for your affidavit. You're not quite ready to put your affidavit together. You're gathering the information and you're making an outline. So you want to include the laws that support your claims, the proof that you can provide to support your claim, the requirements that they failed to follow in order for you to prove your claim, and what happens if they don't follow the law. In some cases, it's $1,000. In some cases, and this may require a little more research, but the penalties are up to $500,000. So, and what damages occurred to you as a result, because you want to put in there your actual damages. If you have actual damages, you want to put them in this affidavit because that's important. What will happen if they do not respond or provide insufficient proof of claim? Because that right there, insufficient proof of claim, is where your win lives. It hides up in that little cave right there, insufficient proof of claim. Always send your documents certified, return receipt requested, and that's with the green card that you stick to the back of it. And always include a certificate of service that states the items you put in there, the number of pages, and the document number. And this is how you prove the contents within the envelope that you sent. And chain of custody evidence for a notary presentment is going to be the notary saying that they included in this document a certificate of service stating the items included, the number of pages, and document number. And they received it from you, and they put it in the mail and sent it. So that's what chain of custody evidence for a notary presentment means. And it's just an added step if you use a notary for your presentment. And they need to attest to the fact that your packet included these items. because you want to notarize the packet, the entire document, not just the one document they're identifying. And let me go over that again because I don't feel like I was clear. Okay, so if you're doing the administrative process yourself and you're using 3 witnesses, you always send certified return receipt requested because the postmaster is a witness, you are a witness, the person who notarizes the document is a witness, and that's your 3 witnesses. If you're using a notary, you still want to send it certified, return receipt requested, and the notary is going to notarize the document, and then they're going to notarize the certificate of service that states the items included, the number of pages and document number. So they're going to notarize the document that you want to notarize, and then they're going to notarize the certificate of service and watch you put those documents in an envelope and address them to the person that you're sending the mailing to. And their certificate of service in your packet counts as chain of custody evidence for a notary presentment. And I hope that was clearer. So the top, this is the screen that I want to take out because it's not formatted correctly. So you know what? Let's just skip over it. Bad. Clearly identify the affiant. For example, notice it is a fact that I, agent for principal, all caps name, and affiant, am a federally protected consumer, holder in due course, attorney in fact for any and all derivatives thereof for the surname, given name, and I have been appointed and accept being the executor, both public and private, for all matters proceeding, and I hereby claim that I will autograph for my given name, my corporate fiction name, and as the agent and administrator in fact. This was a great identity clause, and so I used it because it has all the elements in there. They identified who they are, they identified their standing, their federally protected consumer, the other positions that they hold that give them more and more authority, and then appointed and accept being the executor. It lays that out there and it makes it unrebuttable. If somebody's going to say, well, you know, they would have to attack this clause to be able to overcome their affidavit as far as his standing goes. Let me just not go any further with that. Okay, so use the terms when you're creating your statement of facts. Use the terms provided in federal law. For instance, a credit bureau is not a bureau, it is a credit reporting agency. So how we talk amongst ourselves is not exactly acceptable in legal language. A bank is a financial institution, and a debt collector should be identified as such because they are subject to a particular set of laws. And here's an example that shows why. It's the fact that I, agent for principal, all caps name, and affiant, am a federally protected consumer, holder in due course, attorney in fact for any and all derivatives thereof for the surname, given name, and I've been appointed and accept the executor, both public and private, for all matters proceeding. It's a fact that unless the company can provide a policy or state law which shows that the aforementioned policy or state law supersedes federal law, I hereby invoke the law of presumption and invoke federal law to address the subject matter in the affidavit herein. The reason this is important is, and you don't want to use these words exactly, you know, word it in your own vernacular, but identify the company and what role they play, because this, at this point, you're letting them know that this could get serious really quickly, and you're not holding anything back as far as notice goes. You're letting them know, here's what is happening, here's who you are, and here's who I am. These are the roles that we're playing in this interchange, and if this doesn't happen this way, here's what's going to happen. And it's, if unless they rebut it, you're setting yourself up for a win. So notice it is a fact that I, the agent for the principal, am aware that the company is a debt collector, and then it lays out what the debt collector has to do. So it's a fact that I, agent for principal, have received a statement. I have reason to believe that I, the consumer, owe no such alleged debt. It's a fact that I'm disputing this alleged debt, invoking my specified remedy as original creditor, and until you can provide me with the requested information in this affidavit. It's a fact that I've reason to believe, and do so believe, that in order to assess Your proof of claim in association with this alleged debt and all documents requested in this affidavit must be given to I, the affiant, in order to establish that an alleged debt is owed. I require full disclosure of any accounts, and then here's where it gets really juicy. I demand a statement under penalty of perjury stating that the bank, in fact, loaned the associated debt money from their own assets, because you know they didn't, in order to verify there is, in fact, a proof of claim of this debt. Without this, I cannot verify any valid claims of alleged debts in the name of the principal obligor. And if you're coming into this transaction as the executor or administrator, this is really a statement of your duty to verify the debts. So, and then you have notice it's a fact that I have reason to believe and do so believe that without the requested documents, there can be no proof of claim. And without an affidavit response with a rebuttal point for point within 15 days of receipt of this note, or within a time frame, then I'm conditionally accepting your non-reasonable response as frivolous, and you agree to fault judgment in the favor of the interest of I, the consumer, holder in due course. And so these are some other really good things to put in there. I guess I should have read that last one, but this is the part that, to me, this is something that I messed up on, and I don't want other people messing up on. So we're going to go over this really carefully, because this would have helped me a lot in organizing and having more successes with the administrative process. Each document should have its own reference number. Now, this is a number that you give the document. So, for instance, let's say you have two cases, Capital One and Santander Bank. So, Capital One, you're going to call that case 1. So, you're going to use for the reference number the date you sent it, 1, and 1. So, I put it 1001 because it's the first case, and this is the first document in that case. And then the next step is going to be the cease and desist. I'm going to use the date sent, 1000, because this is the first case, document number 2. The notice to cure, 1000, document number 3. Santander Bank is the second case, so I'm using the date sent, second case, first document. Date sent, 2001. Cease and desist, date sent, 2002. Notice to cure, date sent, 2003. And this helps me to organize my thoughts as far and to know where I'm at in the process, because if I have multiple, and you will, even if you try your hardest to only have one going on at a time, these things take time to cure, and nobody really has time to just let everything cure before they decide to do another one. So you wind up sending more than one at a time, and you wind up having multiple cases going on in multiple steps of the process. So you organize it in a way that gives you the advantage of organization and the advantage of clarity in the process from the beginning. So I really feel like this is a key point for those that are just coming into the process and just starting to want to send these notices and stuff. Sending a notice without any preparation is not going to help you if it's easy and they just dissolve the debt and everything's fine, then yay. But the chances are they're not going to do that. So set yourself up to win from the beginning. And I wish somebody had told me this when I was first starting out. So I'm telling you. Always send copies, because you may need the originals to present in court. You may not need to go to court, and hopefully you don't need to go to court. However, if you do, you will need the original documents. So only send copies in your presentments. Include your certified or registered mail number in the document to further prove service. So you have the reference number that you created, and that's for your internal use. And then you have the certified number or the registered mail number in the document, and also on the green card. That is for tracking it through the mails. If you want to refer to each document using the certified number, you can. However, I found that it made it really difficult because they're all such long numbers, and I don't know what it didn't help me to use the certified number to organize my documents once service had been completed, because I can't look at the headings and tell what case it goes to. It just wasn't a good, complete, organized way of having multiple cases going on at the same time. So that's why I'm suggesting that we should make your own reference number and set it up in a way that makes sense to you, and imagine yourself having several of these things going on and needing to refer to one document, and how is that going to make sense to you to be able to find that document quickly and not have to stress about, well, here's a question that I can't answer because I can't put my hands on the proper document. So next screen, come on. I'm afraid my phone's about to die. Okay, so you want to find the chief executive officer, the chief financial officer, the owner, manager, or if it's a city or a public official, you want to find the risk management department, and you want to send to the attorney general. You don't send legal process, and your administrative process is legal process. You are starting court. This is court. Never send legal process where it'll be received by clerks, data management teams, or customer service, because they won't know what to do with it or who to forward it to. Most likely they'll set it aside and it'll collect dust, or they'll give it to somebody who will send you back a notice or a piece of paper saying, okay, yeah, we got your letter and we're not going to do anything with it. And then when you go to court, they'll say, well, you didn't send it to the right person. So due diligence requires that we find out who is the decision maker at the company that you're dealing with and send your legal process to them for it to be effective, or for it to hold up in the event that you do wind up in court with it. Okay, so your exhibits are documented material proof that supports your claim. If you requested documents from a company and place the burden of proof on the company, then you must have documentation proving that you gave a specified period of time for them to address the matter with proof of delivery. So if you sent them a letter saying, I need you to reply to me within 15 days, you have to certify that request, and proof of certification, or the certification of that request, is your proof, and it is your exhibit. So label in your exhibits or proof via highlighting, circling, or if a recording has been transcribed, audio or video files sent to a regulator. So if you have a list of in one of my cases, I have about 15 certified mail slips, and I made copies of all of them. And when I sent them in, I've circled the ones that were relevant to that case. That way I didn't have to go and make, multiple copies of the same document where I documented all the mailing stuff. So you can circle it, you can highlight on your exhibits, what's relevant here. If you quote the law, you must reference them as exhibits. So if you're using the law within a statement to address how the law affects the subject matter you're referring to, phrase the law in your own words in the affidavit, using only the key terms from the law. Reword the law in a way that shows that you have a clear understanding. For example, if you use the term interstate commerce, give an example that pertains to the matter, such as the transport of mailings. And the reason why is because on the next slide, you don't want to be accused of parroting or copy-pasting law and cases into your affidavit, because this will be deemed frivolous and they may dismiss it and they'll call it frivolous. So you want to print a sheet of reference. This is after you've done your affidavit. Your affidavit is in your own words, stating the facts and giving your understanding of the law and how it applies. And then you want to add a page that is cites and authorities. You want to print a sheet of references. And if you mentioned a law, this is where you put the text of the law. This is where you copy paste the law. And if you mentioned a Supreme Court case, put it in here and you can copy and paste the text exactly as it is. And the reason that you do this is because you want to show that you have a clear understanding of the law, and they cannot accuse you of parroting. And it can be not only insulting, but they're going to try you and they're going to challenge you, and you need to be able to demonstrate an understanding of the law that you're referring to. It's important to reword the law and cases and only copy and paste them here in the cites and authorities, because you have to demonstrate a clear understanding of the law. All right, that's the end of the slideshow, and I believe we've covered everything as far as the private administrative process. And this is just an overview. There is more to it, and there's a lot of different things that can happen during the process, like if they respond and how do you rebut their rebuttal and this, that, and the other. But this gives you an outline to follow and okay, well, I guess that's the end of the recording. Justin, are you still there?
Yes, you're still recording. That was a good job, especially for like beginner type people.